Question 1. In a high-stakes environment where multiple challenges arise from conflicting interests, a company enters into a contract with a supplier to deliver raw materials for manufacturing its products. However, the company faces unforeseen delays in production due to technical issues with the machinery. The supplier threatens to terminate the contract for non-performance. The company claims that the delays were due to the supplier's failure to deliver on, thus preventing timely installation of the machinery. Both parties assert that the contract contains clauses that define timelines and penalties for delays. How should the issue of material breach and anticipatory repudiation be addressed in this scenario? A. The supplier can terminate the contract immediately because the company failed to meet the performance requirements leading to material breach. B. The company's delay due to machinery issues constitutes material breach, and the supplier can terminate the contract only if the breach is substantial enough to deprive them of the contract's benefit. C. The company's delay can be considered as anticipatory repudiation, and the supplier can sue for breach of contract regardless of the delay's cause. D. The company can invoke the impossibility doctrine to excuse the delay, while the supplier may still be entitled to remedies for any delay-related damages. Answer. B. The company's delay due to machinery issues constitutes material breach, and the supplier can terminate the contract only if the breach is substantial enough to deprive them of the contract's benefit. Explanation. The issue revolves around material breach and anticipatory repudiation. A material breach occurs when one party's failure to perform undermines the essential purpose of the contract. Here, while the company's delay may be significant, the supplier can terminate the contract only if the breach is material and deprives the supplier of the benefit of the contract. Anticipatory repudiation applies if party indicates before performance is due that they will not perform. In this case, the company's failure to meet deadlines due to machinery issues may not qualify as anticipatory repudiation unless it's clearly stated that they won't be able to perform in the future. Impossibility is defense, but it doesn't automatically excuse delays caused by machinery issues unless it falls under unforeseen circumstances like natural disaster. Question 2. During a critical transition period where existing processes are undergoing significant changes, a business enters into a services contract with a consulting firm to revamp its organizational structure. The contract includes a provision for payment to the firm upon completion of various milestones. However, midway through the project, the business decides to alter the scope of work, leading to additional demands on the consulting firm. Despite it, to the new terms verbally, the business refuses to pay for the extra work, arguing that the changes are outside the original scope of the contract. Which of the following best addresses the issue of consideration and modification of contract terms? A. The business is entitled to refuse payment for the extra work because the contract was only modified orally and lacks sufficient written documentation. B. The business is required to pay for the extra work under the principle of past consideration, as the verbal agreement was based on prior performance. C. The business must pay for the extra work if it was agreed to as part of a valid modification to the contract supported by mutual assent and consideration. D. The consulting firm is not entitled to any additional payment as the contract was unilateral and the business has fulfilled its part by agreeing to the original terms. Answer. C. The business must pay for the extra work if it was agreed to as part of a valid modification to the contract supported by mutual assent and new consideration. Explanation. In contract law, when the terms of a contract are altered, the modification must be supported by mutual assent, agreement by both parties, and new consideration, something of value exchange. The fact that the business and the consulting firm verbally agreed changes suggests mutual assent, but to be enforceable, the modification should ideally be backed by new consideration. This means that the consulting firm should be compensated for the additional work required. Past consideration does not count as valid consideration, so the business cannot refuse payment on those grounds. The principle of contract modification requires that both parties agree to the new terms and that the modification involves obligations for both parties. Question 3. In a situation where formal requirements conflict with practical business needs, a company enters into an agreement to purchase a batch of goods from a seller. The contract does not meet the full writing requirements stipulated under the statute of frauds, as certain terms were only discussed orally. However, the goods have already been delivered and the company has begun using them. The seller demands payment based on the agreement while the company refuses, arguing the contract is unenforceable due to the lack of a written agreement. How does the statute of frauds apply in this situation, and is the contract enforceable? A. The statute of frauds applies strictly and the contract is unenforceable because it was not written, regardless of performance. B. The contract may be enforceable under the partial performance exception to the statute of frauds as the goods were delivered and used. C. The contract is enforceable due to the doctrine of equitable estoppel, which prevents the company from denying its obligations after accepting the goods. D. The statute of frauds apply in this case as all contracts for the sale of goods are always enforceable under the Answer B. The contract may be enforceable under the partial performance exception to the statute of frauds as the goods were delivered and used. Explanation. The statute of frauds typically requires certain contracts, including contracts for the sale of goods over a certain value, to be in writing to be enforceable. However, there is an exception called partial performance when one party has partially performed the contract. In this case, delivery and use of the contract may still be enforceable despite the lack of a written agreement. This exception is designed to prevent injustice when one party has already performed a significant portion of the agreement. Equitable estoppel could also apply if the company accepted the goods and made use of them, but the partial performance exception is more directly applicable here. Oral contracts for the sale of goods under the UC can sometimes be enforceable when there has been partial performance, even if the contract itself lacks the necessary formalities. Question 4. When dealing with a complex system that shows occasional inconsistencies, the contractor and a property owner enter into an agreement for the construction of a residential building. The contract contains a provision for the contractor to complete the building by a specific date with penalties for delays. However, during construction, the contractor faces a series of unanticipated material shortages which significantly delay the project. The requests an extension, arguing that the delays are due to factors outside their control, while the property owner insists that the completion date was clearly defined in the contract and threatens to terminate the agreement for failure to perform on time. In this situation, how does impossibility and frustration of purpose apply? Options. A. The contractor's delay is minor breach and the property owner is entitled to terminate the contract due to failure to meet the deadline. B. The contractor may invoke the impossibility doctrine to excuse the delay, but only if the shortage was due to natural disaster or other unforeseeable event. C. The contractor's delay due to material shortages may qualify as frustration of purpose, and the contract may be rescinded if it deprives the property owner of the intended benefit. D. The contractor cannot invoke impossibility or frustration of purpose because the contract explicitly specifies the completion date, making these doctrines irrelevant. Answer B. The contractor may invoke the impossibility doctrine to excuse the delay, but only if the shortage was due to a natural disaster or other unforeseeable event. Explanation. The impossibility doctrine can relieve a party from performance when it becomes objectively impossible to fulfill the terms of the contract due to an unforeseeable event, such as a natural disaster or major shortage of materials. If the delay was caused by factors the contractors control and were unforeseeable, they may invoke impossibility as a defense to excuse their delay. Frustration of purpose, on the other hand, would apply if the purpose of the contract has been so undermined by the delay that it is no longer viable. Since the project's purpose, completing the construction, has not necessarily been frustrated, impossibility is more applicable defense. Question 5. In a case where multiple parties have different objectives, a corporation enters into a contract with an individual to provide consulting services for a new business venture. The contract contains a clause that stipulates the consultant must provide advice on business operations, marketing, and strategy. However, after signing the contract, the consultant begins offering advice that diverges significantly from the agreed-upon terms. To disagreements between the two parties, the corporation claims that the consultant's actions constitute a material breach of the contract. Which of the following accurately addresses the issue of material breach and substantial performance? A. The consultant's deviation from the agreed terms constitutes material breach, and the corporation is entitled to terminate the contract. B. If the consultant's actions were minor, they may still have substantially performed under the contract, and the corporation cannot terminate. C. If the consultant performed a significant portion of the contract, it constitutes substantial performance, and the corporation cannot terminate for minor deviations. The consultant's deviation from the terms is irrelevant as long as the actions were consistent with the implied terms of the contract. Answer A. The consultant's deviation from the agreed terms constitutes material breach and the corporation is entitled to terminate the contract. Explanation. Material breach occurs when parties' failure to perform goes to the essence of the contract, depriving the other party of the benefit they expected. In this case, the consultant's deviation from the agreed upon terms constitutes material breach because it undermines the core purpose of the contract, was to provide specific, focused advice. Even if the consultant performed a portion of the work, the corporation is entitled to terminate the contract for such significant breach. Substantial performance would apply if the breach were minor and did not significantly affect the contract's overall purpose. However, in this scenario, the breach appears to be significant enough to justify termination. Question 6. During a comprehensive review of a process that needs improvement, a company enters into a contract to purchase a piece of software from a vendor for use in its operations. The contract includes a liquidated damages clause, specifying a set amount to be paid in the event of delays or failure to deliver. The software vendor fails to meet the delivery deadline, and the company is forced to find an alternative solution to continue operations. The vendor argues that the liquidated damages clause is unenforceable as it constitutes a penalty rather than a genuine pre-estimate of loss. How should the court evaluate the enforceability of the liquidated damages clause? A. The court will enforce the liquidated damages clause as long as the amount is a reasonable estimate of the company's potential loss. B. The clause will only be enforceable if the vendor's failure to deliver caused actual financial loss to the company. C. The clause is unenforceable because it imposes penalty rather than a legitimate pre-estimate of damages. D. The court will enforce the clause regardless of whether it is penalty, as the company agreed to it. Contract. Answer A. The court will enforce the liquidated damages clause as long as the amount is a reasonable estimate of the company's potential loss. Explanation. Liquidated damages clause is enforceable if it is a reasonable estimate of the damages that would result from breach of contract and not penalty intended to punish the breaching party. The test is whether the liquidated amount was fair estimate of potential losses at the time the contract was formed. If the amount disproportionately high relative to the actual loss that could be expected from delay, it could be deemed penalty and thus unenforceable. However, if the amount is reasonable and reflects genuine pre-estimate of loss, the court will likely uphold it. In this case, the enforceability depends on whether the agreed upon sum is deemed reasonable prediction of the company's actual loss. Question 7. When developing a solution that must address the opposing needs, two businesses enter into a contract for the sale of goods. The contract includes a clause requiring the goods to be delivered within 30 days of the agreement. However, due to unexpected shipping delays, the goods are delivered after the deadline. The buyer claims that the late delivery constitutes a material breach of contract, while the seller argues that the delay was due to force majeure circumstances. Which of the following best addresses the issue of force majeure and its impact on the enforceability of the contract? A. The seller can invoke force majeure to excuse the delay, provided the delay was caused by unforeseen and unavoidable events. B. The buyer cannot claim breach of contract because the seller is not responsible for delays under the force majeure clause. C. The seller must still perform under the contract and cannot use force majeure to excuse non-performance in this situation. D. The seller is entitled to compensation for any losses caused the force majeure event, as the delay was not their fault. Answer A. The seller can invoke force majeure to excuse the delay, provided the delay was caused by unforeseen and unavoidable events. Explanation. Force majeure clauses are typically included in contracts to protect parties from liability in the event of unforeseen and unavoidable events, such as natural disasters, strikes, or shipping delays that prevent them from performing their contractual obligations. The seller can invoke force majeure to a delay in delivery if they can demonstrate that the event causing the delay was unforeseen and beyond their control. However, if the event was foreseeable or within the seller's control, force majeure would not apply. It is important to distinguish between force majeure and simple delays in performance that are not caused by excusable events. Question 8. During a critical transition period where existing processes need to be updated, a software development company enters into a contract with a client to develop a custom enterprise resource planning system. The contract stipulates that the system must be delivered within 6 months and meet certain functional specifications. However, 3 months into the project, the client requests several significant changes to the requirement, including new features that were not previously discussed. The development company agrees to implement these changes but requests an additional 3 months to complete the project. The client agrees to the revised timeline but does not provide an additional budget to cover the new features. After the delivery deadline, the system still contains several bugs and fails to meet key functionality requirements. The client demands a reduction in the price. What principle of contract law applies here, and how should the dispute be resolved? A. Impossibility of performance, since the changes were so significant that they rendered the project unachievable. B. Frustration of purpose, because the new features fundamentally changed the project's scope, leading to an unforeseen outcome. C. The doctrine of consideration requires that any modifications to the contract must be accompanied by additional payment, which was not provided. D. The contractual performance standard should focus on the timeline, and the development company should be held liable for failing to meet the deadlines, regardless of the changes. Answer: C. The doctrine of consideration requires that any modifications to the contract must be accompanied by additional payment, which was not provided. Explanation: the doctrine of consideration requires that any modifications to an existing contract be supported by new consideration, such as additional payment for new work or features. In this case, the lack of additional compensation for the new features means the modifications may not be enforceable, and the client may have a valid claim for a price reduction due to the failure to meet the original specifications. Question 9. While investigating a complicated issue between different departments within an organization, a procurement manager enters into a contract with a supplier for the purchase of raw materials. The contract includes specific delivery deadlines, but the supplier consistently delivers materials late, causing disruptions in production. Despite the delays, the procurement manager continues to accept the deliveries and allows the supplier to submit invoices. After several months, the procurement manager attempts to terminate the contract, citing breach of contract for the consistent delays. The supplier argues that the procurement manager waived the right to enforce the contract because of their previous acceptance of late deliveries. Which of the following legal doctrines applies in this situation, and what is the likely outcome? A. Estoppel, because the procurement manager accepted the late deliveries without objection and is now prevented from claiming a breach. B. Waiver, because by accepting the late deliveries without protest, the procurement manager implicitly agreed to modify the original delivery schedule. C. Frustration of contract, because the late deliveries made it impossible for the procurement manager to meet production needs. D. Material breach, because the consistent delays constitute fundamental failure to perform under the contract. Answer: B. Waiver, because by accepting the late deliveries without protest, the procurement manager implicitly agreed to modify the original delivery schedule with explanation. Under the waiver doctrine, when one party to a contract accepts performance that deviates from the terms of the contract without objection, they may be seen as voluntarily relinquishing their right to enforce the original terms, in this case by continuing to accept the late delivery. The procurement manager may have waived the right to terminate the contract for breach. Question 10. In a high-stakes environment where multiple challenges are present, two parties enter into a contract for the development and installation of custom software. The contract includes a clause specifying that any dispute will be resolved through arbitration, with both parties agreeing to abide by the decision of the arbitrator. During the development process, the client requests several changes to the scope of the software, resulting in additional work for the developer. The developer agrees to make these changes, but also increases the price, citing the increased workload. The client refuses to pay the increased price, stating that the original agreement did not include such a change. As a result, the developer initiates arbitration to resolve the payment dispute. How should the arbitration panel approach the issue of contract modification? A. The arbitration panel should enforce the original price because the client did not formally agree to the increase in price for the changes. B. The arbitration panel should consider the implied agreement between the parties that changes in scope may require a price increase even if the former agreement was not amended. C. The arbitration panel should rule in favor of the client, as any change to the contract's terms must be formalized in to be enforceable. D. The arbitration panel should impose quantum merit claim, requiring the client to pay reasonable amount for the additional work performed. Answer: B. The arbitration panel should consider the implied agreement between the parties that changes in scope may require a price increase even if the formal agreement was not amended. Explanation: in contract law, Implied agreement refers to situations where parties act in a way that suggests they have agreed to a modification of the original terms, even if the modification was not formalized in writing. The developers work to address changes in scope, and the client's continued request for modifications suggests that both parties may have impliedly agreed to price increase. Question 11. During an emergency response where multiple areas are impacted, a city enters into a contract with a construction company to rebuild several bridges that were severely damaged during a natural disaster. The contract includes a provision that the work must be completed within 1 year. However, after 6 months of work, the city issues a change order demanding that the contractor use more expensive materials than initially agreed upon, that the higher quality materials are necessary for long-term durability. The contractor agrees to the change but requests an additional payment to cover the increased costs. The city refuses to pay the additional amount, stating that the contractor is obligated to complete the work for the agreed price. What principle of contract law applies in this scenario? A modification of contract requires mutual consent and consideration, so the contractor is entitled to additional payment for the change in materials. B. Impossibility of performance excuses the contractor from the change in materials, and the city should bear the cost. C. The contractor's duty of performance requires them to accept the change without additional payment, as the change was necessary for the safety of the public. D. The doctrine of frustration applies, as the city's change order fundamentally altered the contract's original purpose. Answer: a modification of contract requires mutual consent and consideration, so the contractor is entitled to additional payment for the change in materials. Explanation: a contract can be modified if both parties agree to the modification and if new consideration is provided. In this case, the change in materials increases the contractor's costs, and as such, the contractor is entitled to request additional payment to cover these new expenses. Question 12. In a multi-location scenario where consistency requirements are paramount, a logistics company signs a contract with a client to transport goods across various locations within the country. The contract specifies a delivery window of 48 hours for each shipment. However, due to a severe weather event, one of the delivery locations experiences delays, causing a shipment to arrive 72 hours after dispatch. The claims that the delay violates the contract and demands compensation for the late delivery. The logistics company argues that the delay was due to unforeseen circumstances and requests a waiver of the delivery requirement. Which of the following legal doctrines is most relevant to resolving this dispute? A. Force majeure, as the weather event constitutes an unforeseeable external event that should excuse the delay. B. Material breach, since the failure to meet the 48-hour delivery window is a fundamental violation of the contract. C. Impossibility of performance, as the logistics company argues that it was impossible to meet the delivery deadline due to the weather. D. Waiver, because the client accepted the logistics company's late delivery and passed without objecting. Answer: A. Force majeure, as the weather event constitutes an unforeseeable external event that should excuse the delay. Explanation: force majeure clauses excuse performance delays or failures when unforeseen external events, such as severe weather, make performance impossible or impractical. The weather event in this case would likely be covered under a force majeure clause, potentially excusing the logistics company from liability for the delay. Question 13. When implementing new protocols in a shared environment, a consulting firm enters into a contract with a healthcare provider to implement a new electronic health record system. The contract outlines a specific timeline for training and system rollout. However, due to a lack of coordination between the healthcare provider's internal team and the consultant's team, the training sessions are delayed and the system is not fully funded. By the agreed upon date, the healthcare provider threatens to terminate the contract, while the consulting firm argues that delays were caused by the healthcare provider's failure to cooperate. What legal concept governs this situation, and how should the parties proceed? A. Breach of contract because the consultant failed to meet the timeline for system implementation. B. Frustration of purpose, as the purpose of the contract, successful implementation of the system, has been hindered by external delays. C. Mutual mistake, as both parties were unaware of the scope of the team's unavailability at the time of the contract signing. D. Implied covenant of good faith and fair dealing, which requires the parties cooperate and make reasonable efforts to fulfill the contract's purpose. Answer: D. Implied covenant of good faith and fair dealing, which requires the parties to cooperate and make reasonable efforts to fulfill the contract's purpose. Explanation: the implied covenant of good faith and fair dealing holds that both parties to contract are expected to act in good faith and cooperate to achieve the contract's objectives. In this case, both parties are responsible for ensuring that the air system is successfully implemented. Healthcare providers' failure to cooperate could be considered violation of this duty. Question 14. While investigating a complicated issue between different departments within an organization, a marketing agency enters into a contract with a client for the development of a marketing campaign. The contract stipulates that the agency will be paid a set fee for its services, but the client also agrees to a success-based bonus if the campaign exceeds performance targets. After the campaign is launched, the client argues that the marketing agency failed to meet its obligations, even though the campaign exceeded the target metrics. The agency insists that they are entitled to the success-based bonus as they met all requirements outlined in the contract. What principle of contract law applies in this case, and how should the dispute be resolved? A. Performance-based contract where the client is required to pay the bonus because the agency met the agreed performance criteria. B. Implied warranty of fitness for a particular purpose because the marketing campaign did not perform as expected by the client. C. Quantum merit requiring the client to pay the agency based on the value of the work performed even if the contract was not fully fulfilled. D. Conditions precedent which require that the performance targets must be met before any bonus payment is made. Answer: A. Performance-based contract where the client is required to pay the bonus because the agency met the agreed performance criteria. Explanation: in a performance-based contract, the agency is entitled to the success-based bonus if it fulfills the conditions outlined in the contract. Since the campaign exceeded the performance targets, the marketing agency should be entitled to the bonus payment. Question 15. In a situation where resource allocation becomes contentious, a software development company enters into a contract with a client to develop a new mobile application. The client insists that the application must be delivered within a tight 3-month deadline, while the development company is facing resource shortages due to other ongoing projects. The contract does not include a clause for adjusting deadlines or reallocating resources. The client is adamant that no delays can occur. Which of the following legal doctrines should be considered in resolving this issue? A. Force majeure, since external factors such as resource shortages are beyond the control of the development company. B. Impossibility of performance, as the development company is unable to meet the deadline due to a lack of resources. C. Anticipatory breach, because the development company is unable to perform as promised and may be liable for the failure to meet the contract deadline. D. Contractual performance standard, which requires the company to meet the agreed deadline regardless of the resource limitations. Answer: B. Impossibility of performance, as the development company is unable to meet the deadline due to a lack of resources. Explanation: the impossibility of performance doctrine may apply here because the development company cannot fulfill its contractual obligation to deliver the mobile application on time due to the unavailability of resources. This could potentially excuse the company from liability for the delay. Question 16. While analyzing the root causes of sequential problems in a manufacturing facility, a contract is formed between a supplier and a manufacturer for the provision of raw materials needed for production. The contract specifies that the supplier will deliver materials in accordance with the production schedule provided by the manufacturer. However, the manufacturer's production line experiences significant delays due to issues unrelated to the raw materials, causing the supplier to miss several delivery deadlines. The manufacturer claims that the supplier is in breach of contract. How should the supplier defend itself under contract law? A. Force majeure, because the supplier could not meet the deadlines due to external factors beyond their control, such as production delays. B. Doctrine of substantial performance, as the supplier provided most of the materials in accordance with the agreed terms. C. Excuse of performance, due to the manufacturer's failure to provide the necessary production schedule in timely manner. D. Impossibility of performance, because the supplier could not deliver materials on time due to factors outside its control, such as the manufacturer's delay. Answer: C. Excuse of performance, due to the manufacturer's failure to provide the necessary production schedule in timely manner. Explanation: the supplier can argue that it was excused from performance because the manufacturer failed to provide the production schedule on time, making it impossible for the supplier to meet the agreed delivery deadlines. This can be considered an excuse of performance under contract law. Question 17. During the introduction of new methods where coordination is critical, a construction company enters into a contract with the city to build a new bridge. The contract includes detailed specifications for the design, materials, and timeline. Midway through the project, the city requests several changes to the design, causing a delay in construction. The construction company agrees to the changes but argues that additional time and cost necessary to complete the revised design. The city refuses to pay for the extra time and cost. How should the construction company proceed with this dispute under contract law? A. Implied modification, since the changes to the design were requested by the city and should be compensated accordingly. B. Waiver, because the city accepted the delays without objection and cannot now demand compensation. C. Frustration of contract, because the design changes fundamentally altered the scope of the work. D. Breach of contract, because the construction company did not complete the project within the original timeline. Answer: A. Implied modification, since the changes to the design were requested by the city and should be compensated accordingly. Explanation: an implied modification occurs when one party requests changes that affect the contract's terms and the other party agrees to the changes. In this case, the construction company is entitled to compensation for the additional time and costs associated with the design changes. Question 18. When developing a solution that must address opposing needs, two parties enter into a contract for the development of a new mobile application. The contract specifies that the app must be user-friendly and functional but does not address specific aesthetic requirements. The client insists that the app must meet certain design standards, which the developer argues will interfere with the functionality of the app. After several rounds of development, the app is delivered, but the client claims it does not meet the design requirements and withholds payment. What principle of contract law applies in this situation? A. Objective standard of performance, where the app must meet reasonable standards of functionality and design, even if not explicitly outlined in the contract. B. Doctrine of frustration, because the client's demands regarding design altered the contract's purpose. C. Material breach, as the failure to meet design requirements constitutes substantial deviation from the contract's terms. D. Implied covenant of good faith and fair dealing, requiring developer and client to cooperate in achieving the project's goals. Answer: A. Objective standard of performance, where the app must meet reasonable standards of functionality and design, even if not explicitly outlined in the contract. Explanation: the objective standard of performance requires that the app meet reasonable expectations for both functionality and design, even if those expectations are not specifically detailed in the contract. If the app is functional and meets common design standards, the developer should not be penalized for design deviations not clearly defined in the agreement. Question 19. In a high-stakes environment where multiple challenges are present, a professional athlete enters into a contract with a sponsor for a year-long endorsement deal. The contract stipulates specific performance metrics, such as the athlete appearing at promotional events and using the sponsor's products in public. However, after several months, the athlete suffers an injury and is unable to fulfill the terms of the contract. The sponsor demands of the advance payment, claiming breach of contract. How should the athlete defend themselves under contract law? A. Impossibility of performance, because the athlete's injury makes it impossible for them to perform the contract's terms. B. Force majeure, as the athlete's injury qualifies as an unforeseeable event that excuses non-performance. C. Partial performance, arguing that the athlete has fulfilled some of the contract terms and should not be liable for the full refund. D. Excuse of performance, because the athlete's injury was not foreseeable at the time contract was signed. Answer: A. Impossibility of performance, because the athlete's injury makes it impossible for them to perform the contract's terms. Explanation: the impossibility of performance doctrine applies when an unforeseen event, such as an injury, prevents a party from fulfilling their contractual obligations. In this case, the athlete can argue that their injury makes it impossible to meet the contract's requirements. Question 20. In a situation involving the sale of a unique item, a high-end art dealer enters into a contract with a buyer for the sale of a rare painting. The contract stipulates that the buyer will pay the agreed price within 30 days of the contract's execution, and the seller agrees to deliver the painting by the 60th day. However, after the 30-day period, the seller informs the buyer that the painting has been sold to another party at higher price. The buyer, who has already paid the agreed price, claims breach of contract and demands the painting. How should the court resolve this dispute under contract law? A. Specific performance, because the painting is a unique item and the buyer is entitled to receive it. B. Quantum merit, as the seller may be entitled to the difference in value between the painting sold and the original contract price. C. Liquidated damages, because the contract may specify penalty for breach by the seller. D. Impossibility of performance, because the painting is no longer available for delivery. Answer A. Specific performance, because the painting is a unique item and the buyer is entitled to receive it. Explanation: in contracts for the sale of unique goods, such as art, specific performance may be ordered. The buyer has a right to the specific item they agreed to purchase, and the court is likely to compel the seller to deliver the painting since it is a one-of-a-kind piece. Question 21. When one party breaches a contract involving custom goods, a tailor enters into a contract with a customer to design and sew a custom wedding dress. The contract specifies the materials, design, and delivery date. However, after the dress is completed, the customer refuses to accept delivery, citing concerns about the fit. The tailor insists that the dress was made according to the contract specifications and demands payment. The customer argues that the dress does not meet their expectations, although the tailor followed the design requirements. What legal principle governs the situation, and how should the dispute be resolved? A. Substantial performance, as the tailor has completed most of the requirements outlined in the contract. B. Impossibility of performance, as the dress could not meet the customer's exact expectations. C. Breach of contract, as the tailor did not meet the customer's expectations even if the dress was made as specified. D. Expectation damages, as the tailor is entitled to payment based on the contract price minus any reasonable costs of adjustments. Answer A. Substantial performance, as the tailor has completed most of the requirements outlined in the contract. Explanation: under substantial performance, if the party has completed the majority of the terms and the non-performance is not significant, the breaching party may still be entitled to the contract price with a reduction for any defects or non-compliance. Question 22. In a case involving complex terms and external risks, a software development company enters into a contract with a financial institution to develop a custom banking application. The contract includes a clause that the project must be completed within 6 months with penalties for delays. However, during development, the company encounters unexpected cybersecurity risks that require a longer development period. The software company notifies the financial institution of the delays, but the client refuses to adjust the deadline and demands the application be completed as originally scheduled. How should the software company defend itself in this situation? A. Force majeure, as the cybersecurity risks were unforeseeable and outside the company's control. B. Contract modification, as both parties should mutually agree to extend the deadline due to the unforeseen risks. C. Frustration of purpose, as the unforeseen cybersecurity risks have undermined the purpose of the project. D. Impossibility of performance, as the company cannot meet the deadline due to the unexpected cybersecurity challenges. Answer A. Force majeure, as the cybersecurity risks were unforeseeable and outside the company's control. Explanation: a force majeure clause would likely excuse the software company's failure to meet the deadline due to unforeseen cybersecurity risks. If these risks were beyond the company's control, this clause could relieve the company from liability for the delay. Question 23. When one party misrepresents material facts, the construction company enters into a contract with a city to build a new public park. The contract includes a clause requiring the construction company to use certain environmentally friendly materials. However, the company supplies materials that are not environmentally friendly, claiming that they meet the specifications. The city later discovers the misrepresentation and demands for the materials. Which of the following best describes the legal remedy for the city's claim? A. Rescission of contract, because the misrepresentation voids the contract. B. Damages for breach of contract, as the city is entitled to a monetary remedy for the misrepresentation. C. Restitution, where the construction company must return any payments made for the non-compliant materials. D. Specific performance, as the city is entitled to the correct materials as originally specified. Answer A. Rescission of contract, because the misrepresentation voids the contract. Explanation: rescission of contract allows the city to void the agreement due to the construction company's misrepresentation. The city would typically be entitled to return of any payments made for the non-compliant materials. Question 24. In a case involving non-performance due to misunderstanding, a party enters into a contract with a consultant for business services where the consultant is to provide advice on restructuring a company's operations. The contract specifies certain number of hours to be worked, but the client insists that the services provided do not match their expectations, claiming that the consultant misunderstood the scope of the work. The consultant that they provided the agreed services within the specified time. How should the dispute be resolved under contract law? A breach of contract, as the consultant failed to meet the client's expectations. B. Substantial performance, as the consultant provided services even if they did not perfectly match the client's expectations. C. Quantum merit, as the consultant is entitled to compensation based on the reasonable value of the services rendered. D. Impossibility of performance, as the scope of work could not be determined clearly. Answer: B. The substantial performance, as the consultant provided services even if they did not perfectly match the client's expectations. Explanation: under substantial performance, the consultant is likely entitled to compensation for the services rendered as they provided the agreed work, even if it did not match the client's expectations exactly. The contract was completed to a reasonable degree. Question 25. When unforeseen delays arise in the performance of a construction contract, a contractor enters into an agreement with a client to construct a new office building. The contract specifies a 12-month deadline for completion with penalties for delays. However, due to a sudden labor strike, the contractor cannot meet the deadline. The contractor notifies the client of the delay, but the client refuses to allow any extension of the deadline. How should the contractor address this situation under contract law? A force majeure, as the labor strike is an unforeseeable event beyond the contractor's control. B. Impossibility of performance, as the labor strike makes it impossible for the contractor to meet the deadline. C. Breach of contract, as the contractor is liable for failing to complete the project on time. D. Mitigation of damages, as the contractor must attempt to reduce the impact of the delay on the client. Answer: A. Force majeure, as the labor strike is an unforeseeable event beyond the contractor's control. Explanation: force majeure clause likely covers unforeseen events such as labor strike. In this case, the contractor could argue that the strike prevented timely completion, and the client may be required to accept delay without penalty. Question 26. In a situation involving unclear contract terms, a business consultant signs a contract with a client for services that include advice on optimizing the client's marketing strategy. The contract specifies a fee for services but does not clearly define the scope of work. After the consultant provides some services, the client demands more extensive advice and refuses to pay the agreed fee, arguing that the services provided were insufficient. How should this dispute be handled? A. Parallel evidence rule, as the court may allow oral evidence to clarify the scope of work. B. Breach of contract, as the consultant failed to fulfill the agreed scope of work. C. Implied contract, as the client's actions may imply an agreement for further services beyond the written terms. D. Contract modification, where both parties may adjust the contract terms due to unclear language. Answer: A. Parallel evidence rule, as the court may allow oral evidence to clarify the scope of work. Explanation: the parallel evidence rule allows for the introduction of oral or written statements outside the contract to clarify its terms when the written contract is ambiguous. In this case, the court may allow evidence to determine the actual scope of work agreed upon by the parties. Question 27. In a case involving a contract for services with a dispute over performance, a freelance web developer enters into a contract with a small business owner to create a website. The contract includes a detailed timeline for the website's completion, but due to personal issues, the developer misses several deadlines. The business owner expresses dissatisfaction but does not formally terminate the contract. After the developer delivers the website late, the business owner refuses to make payment, arguing that the delays are a material breach. How should the web developer address this issue under contract law? A. Material breach, as the late delivery constitutes a failure to meet the agreed timeline. B. Substantial performance, as the developer completed the website even if late. C. Waiver, as the business owner did not terminate the contract immediately upon delay. D. Force majeure, as the developer's personal issues were unforeseen and should excuse the delay. Answer: B. Substantial performance, as the developer completed the website even if late. Explanation: under substantial performance, the developer is still entitled to payment even if the performance was delayed. If the late delivery did not significantly affect the business owner's ability to use the website, the developer's failure to meet the timeline may not be material breach. Question 28. When a contract involves multiple parties with conflicting interests, two companies enter into a joint venture agreement to develop a new product. One company is responsible for research and development while the other handles marketing and distribution. However, after the product is developed, the marketing company refuses to distribute the product due to differences in expectations over the marketing strategy. The research development company claims breach of contract and demands damages. How should this dispute be resolved under contract law? A breach of contract as one party failed to fulfill its obligations under the joint venture agreement. B. Impossibility of performance as the marketing company claims unforeseen circumstances prevent distribution. C. Specific performance as the research and development company demands that the marketing company distribute the product as agreed. D. Force majeure as unforeseen circumstances led to the marketing company's refusal to distribute the product. Answer: 8. Breach of contract as one party failed to fulfill its obligations under the joint venture agreement. Explanation: the marketing company's refusal to distribute the product constitutes breach of contract. The joint venture agreement clearly specifies the roles of each party, and the failure to perform obligations results in the other party being entitled to damages for non-performance. Question 29. In a situation where there is ambiguity over terms of performance, a homeowner contracts with a builder to renovate their kitchen. The contract includes a clause stating that the builder will provide high-quality materials for the renovation. After completion, the homeowner believes that the materials used do not meet the standard expected and refuses to pay the full contract price. The builder argues that the materials used meet industry standards. How should the court resolve the dispute under contract law? A. Implied terms as the court will interpret high-quality materials based on industry standards. B. Breach of contract as the homeowner is entitled to refund for subpar materials. C. Substantial performance as the builder met the general requirements even if the materials were not up to the homeowner's expectations. D. Parole evidence rule as the court will allow evidence outside the written contract to clarify what is meant by high-quality material. Correct answer: A. Implied terms as the court will interpret high-quality materials based on industry standards. Explanation: the term high-quality materials is ambiguous and the court would likely apply implied terms based on industry standards. If the builder used materials that are considered of high quality by industry norms, they may be found to have fulfilled the contract's requirements, even if the homeowner's expectations were different. Question 30. When a contract includes a confidentiality clause, two parties enter into a contract where one party, a software developer, agrees to provide software solutions to the other party, a business consulting firm. The contract includes a confidentiality clause preventing the disclosure of proprietary information. After the developer shares confidential information with the third party without authorization, the consulting firm claims breach of contract and demands damages. How should the consulting firm proceed under contract law? A. Specific performance, as the consulting firm seeks to prevent further disclosures. B. Breach of contract, as the developer violated the confidentiality clause. C. Liquidated damages, as the consulting firm claims the contract specifies a set amount for breach of confidentiality. D. Rescission, as the consulting firm seeks to void the contract due to the breach. Answer: B. Breach of contract, as the developer violated the confidentiality clause. Explanation: the developer's unauthorized disclosure of confidential information constitutes breach of contract. The consulting firm is entitled to seek remedies such as damages or an injunction to prevent further disclosures.